Good day, I'm Saiuri Seetal, an associate at Garlicke Bousfield Incorporated. Thank you for giving me this platform today. We're here to discuss a topic that has caused its fair share of difficulties for employers, employees, and courts alike: unprotected strikes in the workplace. To set the scene, imagine it's a Monday morning and everyone is complaining about wages. The shop steward rallies the troops with a fiery speech, and before you know it, workers are marching out of the factory gates with placards in hand. But wait, was the CCMA notified? Was proper procedure followed? Or is this just one big unprotected strike party about to take a treacherous turn? Now, what makes a strike unprotected versus protected? To put it simply, a protected strike is a well-organized party where the neighbors are given notice, the sound levels are in check, and everyone's having a good time. An unprotected strike, on the other hand, is like a surprise party at 2 a.m. with a live band, and trust me, someone's definitely calling the cops. For a strike to be protected in South Africa, certain procedures must be followed. It's not just about collective frustration, it's about collective compliance too. The Labour Relations Act, or the LRA, sets out that workers need to exhaust conciliation processes, issue notice, and meet other procedural requirements before going on strike. If these steps aren't followed, the strike is deemed unprotected. Now, unprotected strikes come with serious consequences. And here's where things get tricky. Engaging in an unprotected strike can lead to dismissal. In the landmark case of NUMSA vs. CBI Electrical African Cables in 2014, the Labour Appeal Court held that employers are entitled to dismiss employees involved in an unprotected strike, especially if they disregard a court interdict ordering them to return to work. While unprotected strikes, sometimes fueled by genuine grievances, the consequences can be disastrous, not just for the individual workers, but for the entire workforce. In Equity Aviation Services vs. Seetal 2009, the Constitutional Court confirmed that even where an employer could potentially be at fault, participating in an unprotected strike is risky business. The court found that dismissals were fair due to the workers' defiance of court orders. The lesson here: sometimes the way you fight matters more than what you're fighting for. The court in Afrox Limited vs. Sakao 1997 laid down the principle that participating in an unprotected strike amounts to serious misconduct. The judgment highlighted that employers must issue clear warnings and, where possible, provide workers with the opportunity to return to work before taking drastic measures like dismissals. But if workers choose to persist, they're likely to be fairly dismissed. Let's add a quick fun fact. Did you know that South Africa is one of the first countries where strikes are constitutionally protected? That's right. Section 23 of the Constitution gives every worker the right to strike, but that is balanced with the need to ensure strikes are conducted within a legal framework. The legal process for going on a workplace strike in South Africa is governed primarily by the Labour Relations Act, the LRA. LRA provides a framework that ensures that strikes are conducted lawfully, balancing the rights of employees to strike with the rights of the employers to continue operations. Let's discuss the step-by-step guide to the legal process. Firstly, identification of a dispute. The strike must be related to a matter of mutual interest between employees and the employer. Example, wage disputes, working conditions. The dispute cannot be about rights that are already covered by law, contract, or collective agreements. These are usually resolved through arbitration or court processes. Secondly, referral of the dispute to the CCMA or the bargaining council. The dispute must be referred to the Commission for Conciliation, Mediation, and Arbitration, also known as the CCMA, or an appropriate bargaining council. The referral is usually done by submitting a completed LRA Form 711 within 30 days of the dispute arising. Thirdly, conciliation process. The CCMA or bargaining council schedules a conciliation meeting to help the parties resolve the dispute through negotiation. The conciliation must occur within 30 days of referral unless the parties agreed to extend the period. If conciliation is successful, the matter is settled and then no strike occurs. Fourthly, certificate of unresolved dispute if the conciliation fails and the dispute remains unresolved. The Commissioner issues a certificate stating that the dispute remains unresolved. The issue of the certificate is critical. It is the green light needed before any strike can be considered lawful. Fifthly, notice of strike action. After the certificate has been issued, employees or the union must give the employer at least 48 hours written notice of the intention to strike. If the employer is the state, the notice period is 7 days. Sixthly, protected versus unprotected strikes. If all of the above procedures are followed, the strike is deemed protected, which means workers cannot be dismissed for participating in a strike. The strike is protected against civil claims, example, damages caused by the strike. And lastly, if procedures are not followed, the strike is unprotected, exposing workers to disciplinary action, including dismissal. Now, lastly, it's during the strike. Even during a protected strike, workers are still expected to conduct themselves lawfully. No violence, intimidation, or damage to property. Employees are not obliged to pay workers during the strike. The no work, no pay principle applies. Regarding the end of the strike and resolution, the strike ends when an agreement is reached, typically resulting in a new or revised contract or collective agreement. In some cases, the employer might apply to the labor court for an interdict to stop the strike if it becomes unlawful, example, due to violence. I'm just going to go into detail about some exceptions to this general rule. Firstly, essential services. Workers in essential services like police, healthcare, and emergency services are not allowed to strike. Disputes in essential services must be resolved through arbitration. Further, maintenance services. If a service is designated as a maintenance service, being necessary to maintain operational continuity, workers are also restricted from striking. Now, what happens if a worker skips these steps? Well, they are stepping into territory of unprotected strikes. Take NUMSA vs. Fries Metals 2005, where the court upheld dismissals of workers who engaged in an unprotected strike after rejecting a wage offer. The court emphasized that while the right to strike is protected, it is not absolute. Procedures exist for a reason. For those wondering if employers are always in the right, it's important to note that the courts do look at the proportionality of the response. In Modise vs. Stevie Spa Blackout 2001, the court ruled that while employees were indeed wrong to strike without following procedures, the employer's rush to dismiss was excessive. The court held that dismissals must be a last resort. This reinforces that while unprotected strikes are risky, employers must still act reasonably and fairly. Unprotected strikes often stem from legitimate grievances. The problem is when procedures aren't followed, everyone loses. Workers risk their jobs and employers face operational chaos. At the end of the day, communication and following the right channels can often prevent these strikes from happening in the first place. So, what's the bottom line? Before rushing into industrial action, workers need to be aware of the potential consequences. Yes, there is power in numbers, but if those numbers are marchingly unlawful, the employer has every right to take action. This could lead, in turn, to hundreds of workers being dismissed with very limited legal recourse. A successful strike is like a great recipe. Follow the steps, get the timing right, and don't skip the instructions. Otherwise, you might just end up with something that's harsh to swallow. So to conclude, workers know your rights, but also know the rules. Employers respect the process, but ensure that your response is fair and proportional. After all, strikes are meant to resolve disputes, not to create new ones. For further questions, kindly contact me on 031-570-5409. Alternatively, you can email me on saiuri.seetal@gb.co.za. Thank you for your time, and remember, always strike a balance.